training with the recording. So, okay, without further ado, I'll hand over to Stuart and Jess, and they can introduce themselves to you.
Great, thanks very much, Vicky. I'm going to try and not break everything and actually present the slides now. So just bear with me for a second. I'll get them up on screen. But yeah, look, thanks very much for inviting us to present this one today. We're very happy to do so. I'm Stuart. I'm a partner here at the pensions team at Eversheds Sutherland. I've been with the firm for just over 20 years now, specialising in all things pensions, but also across LGPS and public sector funds as well. Jess, do you want to just briefly introduce yourself before we get going?
Yeah, sounds good. So, hi everyone, I'm Jess Peart. I'm an associate in the Manchester team at Eversheds Sutherland. I've been at the firm for about 4.5 years now and acting for the fund for about 3. So I work similar to Stu. I work on DB schemes, DC schemes, and also public sector schemes, advising both funds and scheme employers on all things public sector related.
Great, thanks, Jess. Can I just double check you can all see a slide deck of some description that hopefully talks about a training session on procurement and outsourcing?
Yes,
on the screen. Yeah. Fabulous, great, thank you. Right, so Jess, do you want to just sort of briefly sort of set out the aims, and then I'll have a look at some agenda points that we'll cover?
Yeah, sounds good. So firstly, thanks for joining everyone. So this session is focused on procurement, outsourcing, and how that all fits into the local government pension scheme, so the LGPS. So we've specifically designed this session for you guys as service managers across the council. So rather than it being a technical pension session, we're really trying to focus on what pensions means for you in practicing your role. So we're aiming to identify where pensions issues arise and why they matter for your role, and that sort of relates to what you need to do when planning or managing services that involve staff transfers. In our experience and in Vicky's experience, we often find that a lot of issues occur because pensions are either considered too late, or they're not raised with Vicky and the team early enough. So a key theme is to just help build your confidence in understanding your role, how to identify issues early and to manage any risks.
Thanks, Jess. So what we're going to try and do is cover quite a bit of ground in the next hour or so. What I should say, I suppose, is two things. If we slip into too much pensions acronyms and verbiage, then just A, fine us, and B, shout out, because very happy to expand on any points at any time. There's a lot of sort of techie language that often goes with some of this stuff, as there will be in the worlds that you work in. So, by all means, just shout. And equally, as goes with that, any questions as you go, we'll have time for questions at the end, but don't feel like you need to wait until the end. Both Jess and I are very happy to be interrupted at any point. May or may not see hands if they go up. So again, just yell out. It's no problem at all. Quite happy for it to be as interactive, so that you can get as much from the session as you can. But in terms of the agenda, what we'll look at. So I'll take us through a background to outsourcing, what that means in the world of pensions, but particularly in the case of local government and authorities outsourcing, and how that pension protection works, as well as who's got the responsibility to do what. And the reason for doing that is we really want to build up the framework, if you like, as to why pensions is a material issue, but also how it's developed, and therefore why the various structures that are in place exist as they do. Then Jess will take us through so basically the life cycle of an outsourcing from the pensions point of view, looking at some key risk areas, really looking at some of those points around timing and the need to make sure we've got arrangements in place so that we're mitigating the risk of individuals, potentially being in a position where their employment is transferred, but strictly speaking, they don't have any pension provision, which is clearly not a place we want to get into. As I say, we've built in some time at the end for questions, but really happy to take them as they come to you or on the particular topic as we get there. So I suppose we start at the beginning, and given the roles that a lot of you undertake, it would be wrong for me to sort of talk to you about what outsourcing means and how that might apply in terms of what you're doing on a day-to-day basis or project by project basis. So what we've done is really look at this through the lens of the local government pension scheme and outsourcings that apply to public services, and therefore what it means when we're dealing with what ultimately is quite a not just a very valuable benefit, but also quite an emotive benefit for individuals in the form of their pensions. So what we're talking about here is where you've got a transfer of services to a third party, an external provider. Now, this might be the first time those services have been transferred out, or it might be second, third, fourth generation procurement. A lot of services have been outsourced for many decades now, and new providers will come in, they'll have the contract, they'll win the contract, and so we're still moving people along that might have initially transferred out from the council many years ago. It's not confined to, from a pensions point of view, we're not confined to any particular type of service. We're looking at outsourcings that apply across the board. Cleaning services, catering services in schools, for example, highways, social care, any sort of support services. And when you have that transfer, when you have that movement of the service, and as many of you will know, you'll be very familiar with the concept of GP and those regulations which enable or expressly provide for the individual's employment to transfer to the new service provider, to the new contractor. Now, the key in all of this is that the pensions responsibility therefore will change. It doesn't shift completely. It's not an immediate case of all pensions risk has been moved off the table, and Jess will come on to how that's dealt with and how that's addressed later on in the session. But GP sort of probably used on a daily basis by you or referred to in some way, been in place for many decades now. The 2006 version were another update to the initial regulations that I think first came in from the directive in the early 80s. But the purpose of GP is to protect employees' terms and conditions when there is a service transfer and when their employment therefore transfers to the new employer. If there wasn't such a thing as GP, then if the service transferred to a new employer, employment wouldn't transfer automatically by law, and therefore you would be in a position where you effectively have to enter into new contracts. You'd have to novate contracts across to individuals to the new employer, and there would be no guarantees, no protections in terms of their employment rights. Now, that's what GP does. It gives a protection against individuals losing employment rights as a result of their transfer, and so that will essentially cover pay, particular benefit entitlements, but also ensure there is continuity of service. Now, pensions is not covered by GP insofar as there is no obligation, there is no requirement on the receiving employer as a matter of GP alone to replicate the pension benefits that are being built up by an individual before their transfer takes place. There's an express exemption within the GP regulations themselves that says that anything in a contract which applies to an occupational pension scheme, which will include the LGPS, isn't covered by the regulations that otherwise transfer rights and obligations to the new employer. So if we did nothing, if there was nothing else there, an individual's employment would transfer to the new provider, their salary entitlements and other sort of benefit entitlements would move across, their continuity would be preserved, but the new employer would have no obligation to replicate the pension benefits. There are separate regulations which set out a minimum standard now, but they weren't initially introduced when CHUPE went live, and even those regulations only provide for a minimum of a contribution rate into a defined contribution scheme, which is of course very different to the public service schemes. So what happened? Well, this became evident in the 80s and 90s, and it was actually a group of dinner ladies in Lancashire that brought a claim in 1993 that said, hang on a moment, we've had our employment transferred to a new contractor, they're not providing us with the same level of pension benefits. And they actually lost their claim because the court said, well, yeah, that's right, because CHUPE doesn't protect pensions. And it was that case that then led to government then putting protections in place to ensure that where there is a transfer in public service sectors, that there can be continued access to public sector pension schemes, and there's protection for the individual's rights which have been built up. Now, how was that provided? It applies to everybody who transfers under CHUPE. It includes those who are already in the local government pension scheme, so your active members who are employed by in respect to the provision of the service which is being outsourced, but it also includes those who are eligible to join the LGPS in their employment, but even if they've chosen not to contribute, or if they've opted out at some point, they are still protected in terms of having that right to be provided with the same benefit, the same pension benefit, once their employment has transferred. And as we say there, the purpose around all of this and the way the policy developed was to ensure fairness and also the continuity of pension rights in respect of a transfer of services. So why do we have the pensions protections that apply in the context of local government and the public service? Well, as I mentioned a couple of slides ago, CHUPE doesn't fully protect pensions. In fact, as I said, there's an exception. So in the late 90s, early 2000s, the then government produced some non-statutory guidance called Fair Deal, which I'm sure you've heard mention of or come across at some point. And Fair Deal was kind of the starting gun around giving protection to address that issue that had been identified in the case brought by the dinner ladies in Lancashire. The Fair Deal provided, say, non-statutory, it applied to parts of government, not all government, and said that in the event of a transfer out of or an outsourcing of services, then the incoming contractor, the provider, would need to be providing benefits, pension benefits, which are broadly comparable to the public service scheme that the individual was leaving as a result of the transfer of their employment. And that Fair Deal guidance sort of grew a little bit and was adapted at various points. Now, by the time we got to the early 2000s, that Fair Deal guidance wasn't directly applicable to local government. It was applicable to outsourcings from central government departments. And so in 2007, we have the Best Value Authorities Direction, the Pensions Direction. And this is a really important document, 3 or 4 pages long. And it's this document, it's this direction, which requires pension protection to be provided for transferring employees. The direction itself refers to pension protection as being where the individual has changed employer and they're an employee of the new employer, then the rights to pension benefits that they have to be the same as or broadly comparable to, or potentially even better than, the pension rights they had, or they had the right to acquire while they were an employee of the authority. So this put on a statutory footing, if you like, put on a legal footing, the obligation to provide benefits which are the same as, or at least broadly comparable to the rights which were being built up by the employee. Now, importantly, what the best value direction also did was actually enshrine this by saying it has to be in the contract, which is deals with the transfer of services, and that contract must provide that the incoming contractor ensures that pension protection is put in place for each transferring employee, and also there needs to be a provision in that particular pension protection is enforceable by the individual, by the transferring employee themselves. Now, this direction applies to the council here because defined as being a best value authority for the purposes of local government legislation, and therefore it's the council which is responsible for ensuring that protection is in place. It's not just, well, you do the transfer and it's up to the incoming contractor to make sure they're providing a particular level of benefit. This is something which, because of the wording of the direction, the contract itself must provide for. So what this means, in summary, the pension protection must provide ongoing pension benefits, have to be on the same basis, has to apply to all eligible transferring employees, whether they are in the scheme at the time of the transfer employment or not, be covered through express terms in the contract, and also continue for the duration of the contract. So what that means is that it's not necessarily just a case of you let the individual transfers job done. There needs to be monitoring of it to ensure that there is continued delivery of that level of pension protection. And that's also the case if the contractor were themselves to subcontract the provision of the service in some way. Again, there is a need to ensure that contract is being properly administered and managed, so that if individuals do transfer again as part of a subcontracting arrangement, their pension rights aren't prejudiced, they're not impacted as a result. Now, how is this pension protection secured? How is it actually delivered? Well, in your space, in this part of the public sector, typically it's delivered through direct access from the contractor into the LGPS and into the Shropshire Fund directly. And that is where, and come on to talk about this in a bit of detail in a bit, but this is the concept of the incoming contractor having what's known as admitted body status. Now, there are specific provisions within the local government pension scheme regulations which deal with the ability to admit contractors to the funds, to the individual funds, and the terms which need to be addressed in those agreements which are put in place to enable the individual employed to be admitted. The contractor therefore enters into that admission agreement, and as a result they become what's known as the admission body within the fund, and they have obligations as a result of that participation. For completeness, there is an alternative. There is an alternative which is far less common than it used to be. For a period of time, the employers, the contractors, were able either to participate in the LGPS fund directly as an admitted body, or they could provide their own broadly comparable scheme. So they'd set up their own pension scheme. They'd have to go and get that certified by the Government Actuaries Department to confirm that the benefits being provided were at least broadly comparable to the pensions that were being accrued in the local government scheme. But if they could do that and they got that certificate from the Government Actuaries Department, then they would effectively run their own scheme, and individuals would leave the LGPS fund and move across to, X Limited, their own pension scheme. And that was a fairly common option that was available for a period of time. since probably around 2013, 2014, we had a new version of the Fair Deal guidance, which I mentioned, and that really sort of made clear that the starting point, the preference across the board would be direct participation in the local government pension scheme funds. Now, that's why typical approach now, and say 99% of what we see across our client base, but also across other funds, is that the admitted body status is the one that's used. But we mentioned the broadly comparable point because it's not impossible. It's not impossible. You come up against this at some time if you're reletting a contract and it's been out for a while, and there's been various movements of employees. It's perfectly possible that some employees that were originally in the fund, they are still accruing a benefit, a broadly comparable benefit under a separate private sector pension scheme. So in terms of admitted body status, what does this mean? Well, this means that the contractor, third party, joins the LGPS itself. They become an employer which is bound by the obligations of the local government pension scheme. And as mentioned, they achieve this through the admission agreement. Now, the admission agreement is something which is put in place by the fund. It's there in order to regulate the terms on which the individual participates in the fund. It allows the employees to remain in the LGPS, so there's no transfer of their benefits. They're not left in a position where they have to move their accrued benefit in the LGPS fund to a new pension arrangement. They've got continuity of service. They continue to build up their pension benefits on the same basis as they did before the transfer. Now, that admission agreement sits essentially between the admitted body, so the contractor, the council, as what is known as the scheme employer, and we'll come on to that in a moment, and also the administering authority, so in this case the county council, Shropshire Council, as the administering authority in respect of the fund. It's not, I suppose, it's a technical document, but it also has to be linked to the contract that you're dealing with, that you're entering into. The admission agreement will reference the services which are being covered. So it's really important that the admission agreement and the contract that deal with the service transfer are that they dovetail, and they confirm which employees are eligible to participate. So it's really important that the admission agreement terms align with what is actually happening in practice, because only the employees who are employed in terms of delivering that particular outsourced service can remain members of the fund under the admission agreement. So if there's a service change or if the employee moves between roles, that could have an implication in terms of their pension benefit and how that's managed. So you can imagine that, if they are moved, if they're TUPE transferred to a particular provider of cleaning services, for example, while they are employed in connection with delivering the services that you've let, then absolutely fine, carry on. If their role changes within that business that they've been transferred to and they are no longer engaged in providing those services, that is quite possible that's a consequence that they are no longer therefore eligible to continue to participate in the admission agreement. So we need to make sure that those terms align with what the intention is of the service contract that you let. The agreement places obligations on the admitted body, on that third party, includes paying contributions. They have obligations to provide a lot of information to the fund, because ultimately, the decisions they're taking, the actions they're taking will be relevant to how the individual is, whether they're entitled to their benefits, or, if they get an enhancement to their benefits in some way. And obviously the fund has their own disclosure obligations, their own reporting requirements, and we need that information from all employers, but therefore including the admitted bodies. They also need to make various notifications to their employees, which affect the terms of their participation. Under the terms of the admission agreement, typically the council will also act as, if you like, the ultimate backstop. as a guarantor under the admission agreement. So that means that if the contractor is unable to meet its obligations, perhaps due to an insolvency, and I think we've all seen a number of those instances in recent years where contractors have been unable to deliver the contract and maybe they have suffered insolvency, then there is always the risk, there's the potential that the council ultimately carries responsibility for the pension liabilities that have been built up whilst individuals were employed by that contractor. But Jess will talk us through some of the detail on that in a few slides' time. So ultimately, the outsourcing doesn't remove the pensions risk, but it does sort of change how it's structured and indeed how it's managed. So on the next slide here, again, just reinforcing that point, doesn't remove pensions risk. It isn't just a case of, well, we've outsourced the service, it's all on the contractor now. The risk might be transferred to the contractor, it could be shared between the parties, could be retained by or returned to the council. Very much depends on the contract structure, looks at the admission agreement. So that's why having that sort of early engagement around what around the terms of the contract with the provider and the fund, to make sure that the two are talking to each other and they're acting correctly, so we don't have any gaps in terms of liability or gaps in terms of who's covered or gaps in terms of how long the admission agreement needs to be in place for as against the term of the contract. How long, are there any issues which could cause the admission agreement to fall over and to terminate as against the contract? All of those points need to be covered off at an early stage of the process. So in terms of the roles and the different responsibilities that exist here, we've sort of broken it down. Really, there are sort of three key roles, if you like. As the council, you sort of letting the contract. You are, for the purposes of the local government pension scheme regulations, you're known as the scheme employer in that context. You carry responsibility in that regard to ensure that the contract is properly let, but also that the arrangements are in place for provision of ongoing pension benefits. The contractor, the provider themselves, they're responsible for participation, they're responsible for contributions, but they're sort of, if you like, underpinning everything. We've got the pension fund team within the administering authority who have to ensure that relevant participations carry on, that you're getting the contributions through, that member benefits are being dealt with correctly. And ultimately, all of that can only work so long as we've got the right admission agreements in place and the right contractual terms in place. So they're very much distinct roles. Everybody's got their own responsibility, but it's absolutely key that everybody is sort of working together, because if sort of one point falls down, worst case scenario, the ultimate risk is you're working on a contract, you've let a contract where employees have transferred. They think their employment is carrying on, no changes. They think they're paying their pension contributions and therefore they're building up pension benefits. But strictly speaking, legally, if the ducks aren't all lined up in that perfect row and the agreements aren't in place, they're not actually continued members of the fund, because their employment has transferred and their new employer, if they're not admitted, well, they don't have an employer that's participating in the LGPS. So from a overall risk point of view, I suppose, if nothing else, that is the one to bear in mind, because I think nobody wants to have that conversation with an individual to say, well, actually, you thought you were in the scheme, but you're not. Or as I've, for a slight war story I've had in the case where there was a horrendous delay to not this fund, I should hasten to add, not this fund, but a horrendous delay in getting an admitted body through, and sadly 2 or 3 individuals died. And so we had to make sure that there were appropriate arrangements in place to sort of essentially retrofit the admission so that the benefits could be paid, because the individual technically, legally, wasn't an employee at the time of their death to trigger the benefits. So it's those real risks, as well as, of course, making sure that the contractor is doing what they need to be doing in terms of providing the ongoing pension benefit. So in terms of the service manager responsibilities, so as you as the employer, the scheme employer, you're very much there obviously to set up, to design the procurement. It's absolutely critical that you are identifying who the affected employees are, who's transferring across, making sure that when that information comes across to Vicky and the team, that we've got the list of individuals who are going to be covered by the admission agreement. There's an element here that for something called a closed agreement, and that's again quite common, where the only individuals that can be admitted are those who are referred to in the admission agreement and no others. Quite simply, it's sort of, if your name's not on the list, you can't come in. So it's really important that the schedules, that the admission agreements are accurate and up to date with the list of those employees who are eligible because they are currently members of the fund, or those who will be listed as being eligible but they're not currently active members. So from the fund's perspective, we know, or Vicky's team know, who can be admitted. And that helps sort of, again, narrow the financial risk as well. So having accurate details, accurate data is absolutely key to that. And that isn't just to the name of the individual, it'll be things like date of birth, it'll be national insurance number, it'll be details of, when they started in the fund, for example, details of when the contract is being transferred, when their employment is being transferred. And again, this means it all comes back to ensuring that the contracts you're letting and that you're working on and you're procuring, that they properly reflect the necessary pension requirements. Your role, your responsibility is also looking at historic arrangements. As I mentioned, you might be sort of letting a contract for third, fourth generation and some. So where are those employees going from? Where do they move across to? Hi, Vicky, do you want to come in there?
Yeah, I just wanted to add a point on there. Very often when these kind of transfers are happening, the pensions team will be asked for a list of members. Now we can only tell you about who's currently paying into the pension scheme. We won't be able to tell you about everybody at that establishment that might have access to the pension scheme who aren't currently paying in. So those lists will need to come from your HR or payroll teams. So very often when we get asked that question, can you tell us who's paying into the scheme? That's only part of the picture, because there will be other members, employees that work there that have access to the scheme and should have continued access, but aren't currently paying. So we won't know about those people. So that's why those lists have to come from HR and payroll.
Yeah, that's a really good point. I've seen again, not this, I've seen funds be put in a difficult position on that in the past, where the data isn't there, and all of a sudden there are half a dozen employees knocking at the door saying, I need to come in, and that might involve some sort of retrospective changes. It might mean having to update contracts. It might mean, again, looking at the overall financial risk in the contract. So yeah, as you say, Vicky, it's important that accurate data is sourced from the right places. Also, as your responsibilities here are, as I touched on earlier, very much managing the contract and the service provision over time. So looking at where there are triggers that could have an impact on pension provision, whether that's because there is a change in provider, whether there's maybe a redundancy exercise by the contractor. What provisions have you got in the contract that deal with those, and what their impact is on the pension provision. From the administering authority's perspective, its role as administering authority, Shropshire Council is there to administer. They maintain the fund, make sure it's doing what it needs to do. So whether that's from investment to payment of benefits to administration of contributions, running actuarial valuations, setting the funding, so setting the contribution rate, managing the admission agreements, as Vicky mentioned. And from the admission body, they've got to deliver the service. They're responsible for paying the contributions and making sure they themselves comply with the LGPS framework. And some admission bodies, if I'm honest, are more experienced with this than others. Some will, they'll have teams that know what they're doing around public service pension provision, and therefore, from your point of view, you can engage with them and you will have a sensible conversation or discussion around the contract and contract terms, and you'll get that flow of information. Other admission bodies, maybe not as experienced or maybe not engaged with public sector as much, Sometimes it can be quite the headache in terms of getting the detail across to them in terms of what they need to be doing, but also getting the information back that you need to be able to feed into Vicky and the team within the fund. That's me for a little bit. I'm sure you're really glad to hear. So happy to take any immediate questions on those points before I hand over to Jess.
Thanks, Stu. So if there's no immediate questions, I'll now take you through the full life cycle of an outsourcing arrangement. So it's from early planning stage through to the procurement stage, all the way to the end of the contract and what happens next. And I think a key point to bear in mind throughout is the need to engage with the pensions administration team, so Vicky and her team, early, bringing them in at the right stage, particularly before you go out to tender. And Stu's touched on this already. It's just important to make sure that the pensions requirements are properly built in to the arrangement from the outset. And if that happens too late, there might be delays, incorrect pricing, or just issues that will need to be fixed later on. And then basically once I've taken you through this life cycle, that will bring us to the end of the session and we can pause for any questions at that point. So now that we've looked at roles and responsibilities, we're now just going to look at the outsourcing life cycle. So as I've briefly just mentioned, outsourcing isn't a single event. It's a process that runs all the way from the planning stage through to contract end and potentially retendering or bringing the service back in-house. So we'll start with the planning phase, and this is where you'll define the scope of the service, so the catering service, the cleaning service, whatever that may be. Identify the staff that you think are likely to transfer across, which employees are likely to be in scope, and when you think these arrangements will need to be in place. The next step, and this is importantly before the tender process begins, is to engage with Vicky and her team. We can touch on the reasons for that in more detail later. The next point is then going out to tender, and the reason we'll do this after engaging the fund is because there might be specific points like the pension costs based on the fund's actuarial assumptions that should be built into the procurement themselves. Then we'll move on to the pre-contract stage. So that's the point that the parties should enter into an admission agreement. And we've called it the pre-contract stage because that should take place before the contract actually starts. Then the next phase is when the contract starts, and the staff transfer over and the admission body is admitted into the fund. We'll then briefly touch on what happens throughout the contract and the different considerations that need to be made in terms of ongoing management and just monitoring any changes to the workforce and how this will affect any pensions obligations. And then finally, we'll touch on what happens at the end of the contract and when the admission body exits the fund, and also just briefly on retendering and insourcing. Thanks, Jo. So the planning stage, as I briefly mentioned, this is where you define the scope of the service and identify which staff you think are likely to transfer. So at this stage, you're not expected to know with complete certainty which individuals will transfer under GP. That's something that we'll deal with later on in the process. but you do need to identify those that are likely to be in scope. And as Stu mentioned earlier, this is important to understand the pension protection it's important to understand the sort of pension protections that apply to employees while they contribute in the LGPS. And it covers those not only currently contributing, but also those that may be eligible to join. So even if they're not current active members. One of the most common mistakes in this regard is just looking at those employees that are currently participating in the fund. I guess that relates to Vicky's earlier point of they only have the information for the individuals that currently participate, and you'll need to liaise with the HR team to get a definitive list of those that will actually be eligible. So yeah, overall, this is quite a critical stage just because it sets the foundation for everything that follows. And that brings me nicely onto the next slide. So at this point, you should be engaging with Vicky and her team. This is just so that they can start to think about the sort of contributions that will need to be provided, the pension risk approach, whether or not any bond or guarantee might be needed, etc. So the next stage is tendering. So when you go out to tender, the pension requirement should be clearly built into that process. As I mentioned, at this point, you're still just working with indicative employee data, but you should clearly set out what's expected from a pensions perspective, i.e. is that going to be participation in the LGPS through an admission agreement? This is critical because pensions costs can have a significant impact on how bidders price their submissions. And if you don't give them that information at that point, the bidders may be working on incorrect assumptions, and that may result in incorrect pricing or disputes later down the line in terms of the contract. Vicky, did I see your hand come up?
Yes. Yeah, and just to raise the point about cost of pensions and why you need to have that information, we'll need to know about that as you're putting your tender information together. There's kind of two routes. There's what we call a pass-through arrangement and there's a bespoke arrangement, and both cost completely differently. And for your new contractor to understand what the cost of pensions liability might be, you're going to need to know what that cost is and what type of arrangement you want to go with. Now, the fund can't tell you which one to go with. As the scheme employer, the employer that's putting this contract out, it's your decision to decide what type of pension arrangement it is. And this is where it's pretty difficult because pensions isn't your forte. It's the kind of, you're expected to make a decision about these costs and not necessarily understanding what the difference is and what risk it poses to the council, depending on what option you take. So we're here to give you kind of advice and guidance on that, but we're not here to make the decision for you as to whether it should be a bespoke or pass-through arrangement. So we'll probably cover off a bit more about those types of arrangement later on, but as the scheme employer, it's your decision, and that needs to be made before you're putting your tender information out, because that will set the costs, what the contractor will need to pay towards pension liability, and set the kind of scene for who's on the hook for what. So as the scheme employer, you are pretty much like a guarantor to that contractor. If they don't pay what is needed, the fund will come to you and ask for that money. So within your contract, you need to kind of write in there where you're going to be able to recoup that money if you're called upon to kind of make payments to the fund because the contractor has failed. So these are all the risk areas that need to be thought about when you decide on what type of arrangement you're going to allow those contractors to come in on, so that bespoke or pass-through arrangement. So I'll hand you back over to Jess so she can carry on.
No, just jump in there as well, Vicky. I think that's absolutely right. I mean, we'll come on to some of those points in a bit, but you're absolutely right that it's front-end loading all of that because, again, there's always the risk that a procurement gets challenged or it can fail in some way if that information isn't there from the outset. So really getting that construction in place, so you know how you want to run the contract, and that will vary. It will vary depending on the nature of the services, depending on the nature of the length of the contract, but also, where there's sort of a risk balance there, but also understanding who the providers might be. So, yeah, all of that up front, because the last thing you want, exactly as you say, and where we see these at the other end is when everything gets very messy and people start falling out in terms of either a challenge to the procurement or the contractor saying, well, that's not what we bid on, therefore we're going to put additional costs in somewhere else. And unsurprisingly, so again, as you'll have seen, it's not for me to tell you, there's some very sophisticated bidders out there and providers out there who will have teams that look to do this in some cases, and therefore they will sort of looking for every possible angle. So being clear up front in terms of what that pension risk looks like, and therefore the costings of it and the contributions, as Vicky's mentioned, as Jess mentioned, is absolutely critical for that last point, that if the pricing is wrong, then that could cause some real risks further down the line. Thanks, Jess.
So the next stage is what we're calling the pre-contract stage, but this is essentially the point where the admission agreement is agreed and put in place. So up to this point, we've been working with indicative information in relation to the employees covered. And this is the point where everything's confirmed and put in place. And at the same time, the pensions arrangements are finalised. So I guess the key point here is that you shouldn't proceed with starting the contract or GP transferring the employees over until that pension protection has been properly secured. So in this case, the LGPS route is being used. The admission agreement should be completed before the contract starts. As Stu has mentioned, if this step is missed, the contract's live, but the pensions arrangements aren't put in place. So the contractor can't properly participate in the fund, and employees aren't correctly enrolled until that agreement is put in place. So this stage is just making sure that everything is aligned and everything's ready to operate from day one of the contract. So the next couple of slides are going to look at admission agreements in a bit more detail. So as we've touched on, an admission agreement is a legal mechanism that allows transferring staff to remain or be eligible to participate in the LGPS, and it ensures that they have the necessary pension protection in relation to their participation, so they can continue to build up pension benefits for as long as they remain employed in connection with delivering the services under the outsourcing contract. Without it, LGPS participation for the contractor does not happen, and therefore continued LGPS membership for those staff won't happen either. So Stu went through the different roles of the fund, the scheme employer, Shropshire Council, and the contractors earlier, but this is essentially a three-party agreement that they'll all enter into, And as Vicky mentioned just before, it can be structured in a number of different ways. So it may be an open or closed admission agreement to new joiners, and this directly affects contribution rates and risk. So in an open agreement, new joiners, as well as transferring staff working on the contract or services, can be offered membership into the LGPS under the admission agreement, whereas a closed agreement is much more restrictive. And as Stuart mentioned before, it's kind of if your name's not on the list, you're not coming in basis. The agreement will also include the protections involved, so whether or not a bond or an indemnity or guarantee is required. And those sorts of things are typically required to protect the fund and other employers if the contractor can't meet its obligations. As Vicky mentioned before, many admission agreements are structured on a pass-through basis. So under a pass-through arrangement, the contractor typically pays either a fixed contribution rate or the cost of future service benefits. But importantly for you, the underlying pension risk remains with the council as the scheme employer. So although the contract is participating in the LGPS, it doesn't take on the full pension risk. Some of that still sits with yourselves. So yeah, that's it for that slide. So this slide touches on the sorts of information that you'll need to provide for the admission agreement to be put in place. So first you'll need to provide the fund with details of the service and the structure. So what's being outsourced, is that cleaning services, catering services, etc. The contract start date or the expiry date, and any extension options, and also the date that the contract's actually signed. If multiple contracts are being awarded, please also make the fund aware, because legally each contract needs to be covered under a separate admission agreement, and I'll touch on it a bit later, but there's been many cases for various different funds where this wasn't known and the admission agreement was entered into, the contract started, or at the time we thought the contract, it later transpires as multiple contracts, and so steps had to be taken afterwards in order to replace the current admission agreement and set out two new ones to cover the fact that there were two services contracts, for example. You should also flag if any subcontracting arrangements are involved, just because that will need to be reflected in the drafting. In terms of the next bullet point, you'll need to provide details of the contractor's information, so their company name, company number, and the registered office address. So that's just so they can be clearly identified under the admission agreement. The next bullet point mentions the pension approach and service delivery. So I've briefly touched on this in the previous slide, but whether or not the agreement is going to be open or closed to new joiners. In most cases, the agreement's closed. And also how the service is structured in practice. So, for example, if the contract relates to schools or academies, it's sometimes helpful to provide the full address of each site where the services are delivered, just so that it can be easily identified that this admission agreement relates to this contract, etc. And it just reflects how the service is actually operating in practice. So the next bullet point is about employee data. So the full list of transferring staff should be included with key identifying details. So as Stuart and Vicky mentioned before, that's the full names, national insurance number and sex of the individuals, and also whether or not they are active or non-active LGPS members on the start date of the contract. These are often seen as quite small details, but in practice they are the most the detail that causes the most issues in terms of actually finalising the agreement, or later on we realise that something isn't correct and it then needs to be rectified. And it's important that this data is accurate, as it's used by the funds actuary to calculate contribution rates and assess the risk. So if this data is incorrect, it can result in incorrect costs being built into the contract, and as we've touched on throughout, problems later on. And then finally, you'll need to provide the contractor's contact details, and this includes the full name and address of the authorised signatory for the contractor. So that's the individual that will sign the admission agreement on behalf of that entity. At the pre-tender stage, it's important to think about how pension risk will be allocated between the council and the contractor. So this includes whether there's any existing deficit retained or passed through as a result of the outsourcing, and how much pension risk the contractor is expected to take on. So these decisions will directly affect contractor pricing, and it's also important to be clear on the outset what is expected to happen when the contract exit, and any potential payments that need to be made to the fund. So once all that information is provided, the fund will be able to set the contribution rates, assess funding and risk, determine whether any protections such as the bonds, indemnity or guarantees are required, and then we can prepare and arrange execution of the admission agreement. So I thought, and I mean, I've already touched on a couple of these points already. We thought it would be useful to talk through some common areas of confusion or common pitfalls that we see. So the first one is the distinction between the contract date and the contract start date. So the contract date is the date on which the contract agreement is signed. And this is helpful and included in admission agreements in order to identify the relevant services contract. The contract start date, on the other hand, is the date when the services actually begin, and quite often they're not the same date. And sometimes there's confusion between the distinction between the two, and that can affect the drafting or cause delays. The next point is identifying the indicative employee list and the final employee list. So as I mentioned briefly before, sometimes not all employees that should have been covered under the admission agreement are, because for one reason or another they've been missed. So it's just important to go over the list with a fine-tooth comb and just make sure that no one has been missed. The next is kind of related to the previous point, and it's identifying which individuals will be active LGPS members and which will be non-active LGPS members. It's important, one, for in terms of the drafting of the admission agreement, that this is included, but also because it will affect the fund's risk calculations and contribution requirements as well. I've already touched on the fourth point. So just where there's multiple service contracts, we need a separate admission agreement for each. So I won't go over that point again. And finally, transfers don't always take place at a single point in time. And sometimes employees can be phased over. And where that is the case, it's just important that that's flagged so that, again, that's considered in terms of the fund's risk calculations and also just how it's drafted in the agreement, so it's clear when certain employees are eligible to participate in the fund. So this is kind of related to the slide before. It's some common pitfalls that we see. So we've mentioned throughout, but engaging with the fund too late, also using incomplete or inaccurate employee data, and that can create problems that will persist throughout the life of the contract until they're identified, and then we somehow need to find a solution to fix them. The next one is treating pensions as something separate from procurement, and quite often pensions is a side thought or forgotten about, but I hope that this training's shown it's actually quite an important aspect that should be considered right from the start. We've already mentioned it, but the admission agreement not being put in place before the contract starts. Another one is not understanding historic arrangements, so particularly retender or exit. So it's important to understand what has been agreed in earlier arrangements, and this includes how pension risk was allocated, whether the council acted as guarantor. So having a clear audit trail of those decisions is critical, as it determines who's responsible for any deficit or surplus when the admission body exits the fund. And without that sort of clarity, difficult conversations can arise later on about who is ultimately responsible. So in particular, where the council has acted as guarantor, there needs to be clear discussions at contract exit with the contractor about any deficit or surplus, and who's responsible for meeting that position. I mean, particularly if there's a deficit. And so those conversations should be agreed at the outset. Another point is that outsourcing decisions are sometimes made without central oversight. So, for example, at service level or at the LEAs, where that happens, pension requirements can be missed or picked up later, which can again lead to delays, additional costs, and needing to revisit decisions. So I guess, I mean, although you don't know what you don't know, it's more just to be mindful of this point, and that can sometimes happen. In practice, it's also helpful to have a clear lead officer or central point of contact for coordinating the process. And that individual can be the main link between the council, the contractor and the fund, just to ensure that all the right information is provided, and that nothing is missed. And then the final point relates to subcontracting. So this is where a contractor lets part of the outsourced service to a subcontractor, and where pension protection obligations apply, it's important to know that they don't just stop at the first contractor. So if staff transfer to a subcontractor, that subcontractor also needs to provide appropriate pension protection. And so the council remains responsible for ensuring that that protection is delivered in these circumstances. And just, I mean, those 3 bullet points sort of highlight what we've mentioned throughout. So any changes can cause delay, cost and risk to members, please start early, and employees have a legal right to pension protection. So yeah, it's very important. And then this slide is just a very brief one about what happens when the contract starts, and in terms of ongoing management. So at contract start, the staff will transfer to the contractor under TUPE. So the contractor becomes an admission body in the LGPS, and pension protection at this point should be fully in place and operational. As we've mentioned time and time again, if this isn't the case, then employees can't be correctly enrolled, contributions may not be paid properly, and issues can arise quite quickly. And then in terms of ongoing management, so the next little section, pensions responsibilities don't just stop once the contract started and the employees transfer over. They continue throughout the contract. So it's important to monitor workforce changes, for example, and service changes, and ensure the correct employees remain in the LGPS, and that the data remains accurate. So it's more just making sure that ongoing communication and dialogue continues with the fund, yourselves and the contractor, as anything missed will have or may have pensions implications. Yeah, so that's that slide, and I think I'm handing back over to Stu now.
I'll pick up just to finish off, Jess. Thanks very much. So we sort of run through that life cycle. A lot of work up front, the monitoring, but before you know it, the contract might be relet or is expired, and that's when I suppose the work and the effort that's been put into the initial procurement phase and the contractual terms and agreeing the admission agreement, that's where often there's a risk that things unwind, or actually you can make, you know, everybody's life is much easier because the contractual terms and the admission agreement are working together to very clear as to where those risks and those liabilities lie. And what we sort of set out here is that if there wasn't a pass-through arrangement, by which we mean that, you know, ultimately the contractor pays a set amount, and then at the end of the terms, then that's it largely, you know, the risk or of a deficit, or if there's a surplus, that's not one that the contractor gets involved in. That's for the council. But if we don't have those sort of pass-through arrangements, which I'll talk to again a little bit in a moment, then at the end of the contract, the emitter body exits. They're no longer employing any active members in the fund because their employees have transferred out elsewhere as part of the retender of the contract, or it's just come to an end. So they're not employing their active members. That means they exit from the fund. Now, under local government pension scheme regulations, that requires something called the exit valuation to be undertaken, and at that point there's a calculation to determine whether that admitted body, its participation and the employees that are that it's been responsible for, that have built up benefits whilst they've employed them, work out, well, actually, have they got a deficit? You know, has the funding in respect to that group of employees from that admitted body, has it met the value of liabilities that have built up? And that can sort of change significantly over periods of time, based on how those liabilities are costed, down to things like investments, down to wider economic factors, mortality rates, goodness knows what. So there are lots of different factors that can take into account, as well as, you know, experience of that staff, whether, you know, levels of pay or levels of early retirement and the like. So that can all contribute to the liabilities that have built up during the lifetime of the outsourced contract. And therefore, at the end, the bit that's attributable to that employer, there might be a deficit. And if there's a deficit, then on a non-pass-through arrangement, then the exiting employer needs to meet that deficit in some way. Equally, if there's a surplus because the assets have done better than the liabilities, then there's a possibility, it's not a right, there's a possibility for that surplus known as the exit credit to be paid in part or in full to the exiting admitted body. And that can really get into some difficult ground where you've got an admitted body that's exited and they're saying, well, actually, there's a surplus that's been built up. That's because of the contributions we've been paying, or that's down to us assuming the risk. Therefore, we want all of that credit, or we want a share of that credit. And there's been lots of instances of claims being brought in. There's even been cases have gone to court in terms of claims around those credits. So it's really important, again, from the outset, to be very clear: are we sort of entertaining a contract of that nature where there's a risk that's being accepted at the exit point, so that potentially there's a debt that needs to be paid or a credit that needs to be reimbursed? That will be the starting point. If we did nothing else, that will be the position under the regulations. So as Vicky mentioned, we've got pass-through arrangements, which not just for this fund, but more generally, we see a largely the typical approach. Not always. I mean, there will be variations depending on the nature of the contract or the commercial agreement, but quite often there will be a pass-through, which means that there's certainty, I suppose, for the admitted body in terms of they know they're not carrying risk at the end of the contract. They're paying a contribution, and the council, the scheme employer, ultimately will guarantee or will be responsible for the liabilities which are built up. In that scenario, the admitted body may not meet the deficit because that's how the pass-through works. You could still have potentially a bond or an indemnity, by which we mean that there's a bond put in place with a financial institution, and that bond gets called upon by the fund if the admitted body doesn't pay its contributions on time or doesn't pay any amounts that it has to pay to the scheme on time. But when you're putting those bonds in place, that can be expensive. That can be an additional cost for the contractor. So sometimes not requiring that bond and having a pass-through helps in terms of the overall costing of the contract and the letting of the services. So those, again, commercial factors which are taken into account. But if it's pass-through, then when the contract comes to an end and the admitted body exits, if there's a deficit because the liabilities it's built up have exceeded its assets, or the contributions it's paid haven't quite met the liabilities, then those liabilities basically they're carried on. They're assumed by the council. They're sort of built into the council's overall sort of tab, if you like, its own liabilities in the fund. Equally, if there's a surplus, if there's a credit, then that's credited to the council's participation in the fund, its own assets and liabilities in the fund. But you're not then getting into engagement and discussions with the exiting employer around who's entitled to what proportion of the credit. So that exit outcome and the smoothness with which there can be a transition from contractor A to contractor B, or the way in which an admission is dealt with when it comes to an end, really depends on getting those decisions clear and well documented from the start. And clearly that's really important as well, if to guard against the risk of an insolvency or a failure by the admitted body. If they're not around, who's picking up the cost? Is that one that there's a guarantee from another party, a parent company, for example, or is this passed through? So as the scheme employer, we know we're carrying a bit of a risk there, but by and large, we've got the upside if there's a credit that's due, would otherwise be due at the end of the contract. So having those engagements and as Vicky mentioned earlier, making sure that the fund are well aware, that's really important, because that goes to the way in which the admission is set up. It's critical to the information that you need or that you're providing, but also to setting the contribution rates. the contribution rates will be influenced by these factors and these decisions. So what happens next once you've got to the end of it? You're retendering. Well, we'll go back to the start in a way. The pension protection obligations, they continue. Is there then a need to look at the contribution rates again? Experience will have moved on, liabilities may have moved on, the funding position of the scheme, the fund itself will have moved on. Looking at the different type of risk that might be assumed, the new provider might have a different appetite for, you might have a different appetite for risk, or it might be a different sort of contractor to the one that has exited. It might be a different conversation around security requirements or the terms on which you're prepared to admit them to the fund. And all of those costs are then built into the procurement from the outset. Potentially, there could be an instance where the service is brought back in-house, and therefore, well, that's, you know, the individuals just continue back in the LGPS as before, and less of a need for an admission agreement there, because they'll be coming back into an entity that is already a scheme employer in the fund. So yeah, all about early engagement, getting the planning right at the get-go. Being aware that, say, some of the providers out there are pretty sophisticated and will have be looking at this through a lens to try and minimize their costs. Equally, you'll have providers who, you know, don't have teams looking at this. They don't have great amount of resource, and they might need a little bit more sort of pushing and shoving or degree of hand holding. But it's really critical that from your perspective, when you're running these procurements, that you've got a very clear set of terms, very clear position in terms of where that risk is going to sit. That all flows through to contribution rates, therefore through to cost, and absolutely hopefully then mitigates issues further down the track. So that, I think, brings us to the end of the deck. A lot of detail and sort of pensions points in there, but again, really happy to take any questions, or equally, Vicky, from you and the team. I don't know if there's anything else you want to go back on or raise again, but say really happy to take any final points on this.
Stunned silence. So
never sure if that's a good thing or a bad thing, but yeah, hopefully that's got some useful takeaways for people.
Yeah, so thanks, Stuart and Jess, for presenting. Oh, Neil, thank you. You've got a question.
Yeah, thanks for that, and thanks for the presentation. Really, really useful, really helpful. Got one or two questions. So firstly, when we're talking about, well, I suppose, firstly, sort of how long before we are planning to go out to tender should we be contacting the pensions team to kind of start this ball rolling? I mean, sort of any ideas as to, or any advice as to how long this process can take from, you know, when we first contact you and say, you know, we're planning to do this, we understand that there's going to be people in the pension fund that need to be considered. I mean, are we talking a year in advance? Are we talking 6 months in advance? What sort of rule of thumb have we got?
So as soon as you know that a service is being considered for outsourcing, it's useful to kind of just give us a heads up. It will depend on the type of admission agreement that the service want to agree to, so that pass-through or bespoke arrangement, as the amount of time it might take to get that information together. So on a bespoke arrangement, we need more lead-in time, because the actuary will have to do some calculations to look at that particular group of staff and work out what a bespoke contract employer contribution rate might look like for that new contractor. Whereas with pass-through, it's a much more simpler process. Pass-through is looking at paying the same contribution rate as the scheme employer, so the same primary rate as the council. So we already have that number, and so it's just understanding what level of risk and what type of admission agreement is going to be looked at for this outsourcing for the kind of lead-in time that we need. Pass-through is much quicker. bespoke would need more time for us to go away and calculate an employer contribution rate for that particular group of staff.
Thanks. Okay, thanks for that. And just on that, and sorry if I may have missed it earlier on, but bespoke versus pass through, does it depend on the kind of the financial standing of the new or the incoming employer, or is that something that we, because of the nature of whatever it is that we're outsourcing, determines that it's pass through or bespoke?
So there's a number of different factors that need to be considered on what type of arrangement the council are happy to kind of allow for that contractor. Bigger contracts where you're talking about huge numbers of staff, and there's greater risk. It's probably more sensible to consider that bespoke arrangement, because the contractor is on the hook for most of that liability and the risk and the cost. Whereas with smaller transfers of staff, a pass-through arrangement is a much simpler process, and it just means that contractor will pay the same rate as the council, and then once that contract comes to an end, any surplus or deficit is just subsumed, so included back into the council rate, and that is kind of a much smaller risk to the council in essence. So it can be different depending on what the group of staff is, the length of contract as well. If we're talking about long contracts or short contracts, all of that kind of builds into the amount of risk that is attached to that contract and the level of pension liability that then might become due around that group of staff. So it's kind of on an individual basis. We would have to look at the type of contract, the number of staff, and the length of that contract to kind of understand what should be considered with the risk that's attached to it for the council.
Okay, thanks for that. And then one final question from me, if that's okay. We talked about obviously people that are current members of the scheme, but then there's also potentially, and I can't imagine it's that common, but potentially there are some people who are eligible to join the scheme, but they haven't. Is there a point at which those people who were eligible but haven't joined the scheme yet no longer have the right to join the scheme, or does it kind of just follow through on, from contract to contract to contract, that they may at some point join if they wish to?
Yeah, that's exactly it, Neil. You're absolutely spot on. That once you're in the group, if you like, and you're being, you've been outsourced, but you're providing, you're employed in connection with the provision of those services, so you sort of meet that eligibility criteria, then even if you decide not to join, you could always opt in at any point, and therefore you'd, even if you've been moved from employer A, B, C, and D all the way through, the data should reflect that you are a non-active but eligible employee, if you like, and therefore they could at any point in those subsequent employments decide that they want to join. As you say, I suspect that's not too many, but there will always be a couple that they're in that camp. But there's no sort of end date that says, right, that's it, you've not enrolled by this point, or you've not been part of this particular contract, therefore you lose that eligibility.
Yeah. And it can depend on the type of facility or service that you're running. So, for example, leisure centres have a lot of casual employees, and they will retain that protection even if they've not come into the scheme. So if they remain at that leisure centre and are part of a second, third, fourth generation transfer to different contractors, they will still have that option to join the LGPS. So that's why it's important that the kind of tracking of the original group of staff is there, and we can understand who should be eligible and who isn't.
Thank you. That's really helpful.
Peter's put his hand up because he's leisure. Might have a question about that.
Yeah, fallen into some of the traps that you've been discussing this morning, unfortunately. Neil, you've asked one question I was going to ask. So does that follow up from that? Does that relate to new employees of the new contractor? They're not eligible to join the LPGS, are they? They'd have to go with the contractor's terms and conditions and their pension scheme. Is that correct?
Yeah, that's right. So long as, I suppose, so long as the admission agreement is set up on a closed basis.
Yeah.
So you've got your finite group of those that can join. Then yeah, absolutely, Peter. Yeah, you and that's something again to as part of those negotiations, or as part of the proposal, if you like, from the engagement with the contractor, so that you're not left with this open door where anybody that might be hired at any time during the contract in relation to those services all of a sudden has LGPS membership. I mean, that would be clearly relevant to then setting, risk profile and contributions and the like. But you're absolutely right. So you've got a closed arrangement. Anybody that then gets hired in subsequently during that contract by the provider, even though they might be working on those services, provider T's and C's, whatever contract, whatever pension arrangements they've got. I mean, we've got to keep an eye, I suppose, to developments around sort of two-tier code and two-tier workforce that, that there are thoughts around and discussion documents around. But, the principle is exactly as you say.
Okay, thank you.
Lovely. Any other questions? Well, okay, so thank you to Stuart and Jess for the presentation. I hope you find it helpful and useful. We will be sharing the recording and the slides so that you can watch it back and have a look at the slides again. But if you've got anything going on outsourcing wise, we're here to help. We're here to support, particularly around the pensions issues and making sure that's picked up as early as possible, because it then doesn't create any issues for you further down the line with contracts and pricing and contractors not understanding what they are responsible for when it comes to pensions. So yeah, thank you. You can have some time back, enjoy the rest of your Friday, and have a lovely weekend. Thank you. Bye.
Thank you.
Cheers,
Thanks
thanks.
all. Bye-bye.
Thank you.